Your patent sucks. An overview of the reasons why your patent may indeed suck. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please like, follow, and share. So, sticking a bit to the brand name, if you will, we're going to, in this video, list an overview of the reasons, probably not all the reasons, but the big ones that I found in my practice, the reasons why you may have a patent and it may indeed suck. We'll then discuss the different reasons specifically in individual videos that are directed to them. But for now, this will help you have, like in one place, sort of a checklist of things you can think through when you're evaluating a patent and deciding whether it's worth anything. So, and not every reason will apply. I mean, to some extent, whether some of these reasons apply depends on what your strategy is. In particular, if you really got a patent just for marketing purposes to say your product is covered, then a lot of these won't be a big deal. So I'm really assuming with this list that you got a patent with an eye towards market exclusivity and possibly enforcing it in court against an infringer. So one of the first reasons your product may suck is because, or sorry, your patent may suck is because it's easy to design around. If it's easy to avoid your patent claims while still providing a competitive product, then your patent may suck. Another reason your patent may suck is if your patent doesn't cover your own product. You know, again, just because you put drawings of your product in the patent application, if you don't make sure your claims actually encompass your product, your actual commercial product as you released it into the market, then people can copy that product without fear of being sued on your patent. You've got to make sure that the claims, at least some of the claims, read on your product. And that means that your product has every element of at least one independent claim. If that's not true, then you don't have a product that's patented under your own patent, and that definitely can make your patent suck. Another reason your patent may suck is because you don't have claims that hedge or act as a hedge against invalidity. The reason why patents have so many claims in them, and in particular so many dependent claims, is as a hedge against an invalidity attack. Just because you got the patent doesn't mean that no one can attack its validity. They can attack it in court and they can attack it in the patent office. The dependent claims are there because if the independent claims fall and an infringer still infringes a dependent claim that has not fallen, that survives an invalidity attack, then they still infringe. So we don't know what prior art's going to surface down the road. You know, the searches we do before we write a patent application and the searches they do in the patent office are not nearly as exhaustive as what an accused infringer will do when they're trying to invalidate your patent because you're threatening to sue them for patent infringement. So you really want a patent that's well protected with an array of good and meaningful dependent claims that are likely to survive an invalidity challenge if one should ever be raised against them. Your patent can also suck just because the claims are generally vulnerable to an invalidity challenge. Now, there's a number of grounds for invalidity. I'm not going to go through what the requirements are, but in short, if the claims are invalid over the prior art because they either lack novelty or because they're obvious, that's a basis for invalidation. If your specification does not teach somebody of ordinary skill in the art how to make and use the invention, that is a basis for invalidating the claims. If your specification does not convey to a person of ordinary skill in the art that you, as the inventor, actually invented what you claim to have invented, then the claims can be invalidated for failing to comply with the written description requirement. If your claims are indefinite, if they're not, if they can't be interpreted so as to be reasonably precise and so that their scope can be reasonably ascertained by a person of ordinary skill in the art, then they're indefinite and invalid for indefiniteness. If you have committed inequitable conduct because you didn't disclose information that was material to patentability of the patent office and you did so with an intent to deceive the patent office, the entire patent can be invalidated, and that would definitely be a reason that your patent may suck and actually suck severely. If the market has moved so fast that your technology is no longer relevant in the patent, then that patent may very well suck. if you fail to mark your products with your patent number, it's not really a defect in the patent itself, but it's something that compromises the value of the patent because it can reduce your damages awards significantly, then that may be a reason your patent sucks. And also, in a related vein, if damages are really hard to prove, if it's not even though it's novel, not obvious, it might get a patent, it might be the kind of thing that it's hard to show has any value. And with a utility patent, there's no statutory damages. You have to prove there's actual damages and that you're entitled to a reasonable royalty or lost profits. And if the contribution of the patented invention to the value of an overall product is minimal, then you're not going to be looking at any money. People aren't going to want to license it. And unfortunately, in that instance, your patent may very well suck. So that's a list of the reasons that a patent may suck. I'm not saying it's all of them. There can be more. But those are certainly one of the big ones. And in future videos, we'll take a look at them individually. I hope it helps to keep you out of trouble. And I hope to see you here soon.